So Florida's judicial system just ended one of the darkest periods in its history, and that was the end of the second or third or whatever round of the foreclosure rocket docket procedures. We just ran out of the funding that the legislature provided, gave to the banks to flush out all their foreclosure judgments, and ended what was, again, a dark period in our judicial system because, in my view, and the view of many practitioners, frankly, any defendant that appeared in front of a court, the court stepped out of its role of neutrality and objectivity and then began acting in fulfilling the interests of the legislative, executive branch, and the banks and corporations that paid to have a judicial system that suited their interests. My evidence in support of that statement is, of course, the anecdotal examples that we all experience every single day walking into a court system that was clearly biased against the interests of individuals that appeared before them. I had many, many ugly examples, and any practitioner can point to dozens, perhaps, of just really bad examples of the bias that existed within the judicial system. As a matter of fact, just this morning, I got a final judgment of a case that represents what is all so wrong with what happened in foreclosure court. I was approached by legal aid and asked whether I would agree to represent pro bono, no charge, an elderly woman who was having her only home, her only place to live in, foreclosed on by a lender that had absolutely no business in foreclosing. But I'm not just talking about, some technical arguments about not being able to verify records or didn't get a proper default letter or anything else. No. What I'm talking about is an elderly woman who tried desperately to get a reverse mortgage on a property that was eminently reasonable. We're not talking about crazy numbers that she couldn't afford this house. We're talking about a very reasonable house that this elderly woman on a fixed income could absolutely have figured something out. She wasn't able to because the lender that had the loan on the property screwed up on the paperwork and didn't release it properly when she'd reduced down her mortgage. Now, that's kind of technical, but let me tell you exactly what the substance is. The legal description is the description of the property that's being foreclosed on. So in this particular case, they had a legal description on her mortgage and on her house that was completely wrong. A series of transactions over years made that legal description describing, frankly, not her house, but a multi-million-dollar house across the street on the water, and that was the legal description that's contained within the court papers from the beginning of this case that's only been going on for 2 years or so. But the reality is the bank screwed up when they filed the foreclosure, and they described not this elderly woman's house, but the multi-million-dollar house across the street on the water. Well, they went through the trial, and the judge just disregarded all of this black and white testimony about they got the wrong legal description. And the dopey plaintiff's attorneys that came in there just didn't even care and disregarded it. But the judge said, even though we know that it's a wrong legal description, let's not even care about that. Plaintiff, just get me some kind of legal description, correct it, and I'll sign it. Well, at that point in time when I became involved in the case, and I looked at all of this, and it was exactly correct, and I went before the judge, and I said, Judge, this is a legal aid case, and this elderly woman that's standing in front of you here, and these legal aid attorneys, we got a little problem here, because we all know what happened. We got a wrong legal description. And Judge, I would just urge you to exercise a little bit of restraint here. Let's take a look at what legal description they propose, and then let's not sign that until we have an opportunity to explain to you that it's wrong. Well, I couldn't believe it that after that time, the judge dusted me off, sent us all out, quite frankly, in a very perfunctorial manner. Just said, I don't care about this. We're going to sign a judgment, basically. And even with that, I still had hope that maybe the judge would reconsider that and not sign a final judgment. Well, just this morning, I get this final judgment. Now, I talked to a surveyor. I hired a surveyor yesterday and had him look at the proposed final judgment. And in fact, that surveyor confirmed everything that was wrong. The legal description's wrong. So you look at this, and I filed all these things with the court, said, Judge, please don't sign this final judgment, which is erroneous, and in fact contain pieces of parts of adjoining property. So you can't sign this final judgment because not only does it not fit evidentiary burdens and all these other technical arguments, but you're impacting the rights of property owners all around you. It absolutely is flabbergasting to me and disappointing to know that today that judge signed that final judgment. So what are we going to do? Well, we're absolutely going to appeal. We're going to explain to the judge again why it is that you shouldn't have signed a final judgment that contains pieces and parts of property all around, and that the plaintiffs totally failed to meet their evidentiary burden, and we're going to try to get the appellate court's attention. The problem with appellate courts right now is they're inundated with appeals on all kinds of cases, in particular with foreclosure cases. And far too often, the appellate court just says, to heck with it. Let the plaintiffs figure it out. Let the other people figure it out. We're just not going to write a written opinion there. So for people who think that I'm going to appeal and the appellate court is going to recognize the gross wrongdoing that's occurred here and they're going to write a written opinion, it's just not true. That's not an accurate representation of what's actually happening in appellate courts right now. In this particular case, the worst part about it, and the conduct that's occurred in state courts all across the state by the plaintiff's attorney, the very worst thing is that these attorneys on the other side, the plaintiffs in particular, are conditioned and educated to recognize that they can get away with gross improprieties and have judges sign off on these things. And in this particular case, again, very solid legal arguments that there's just no evidence, no competent evidence, much less competent substantial evidence, that can support a legal description that came to fruition, that came into existence after the trial was held. But for this young attorney that was able to stand in court with no basis in law or fact and convince a judge to sign this thing, she's learned that she can get away with it. Now, I've got many other examples of gross conduct on the part of plaintiffs' attorneys who waltz into court engaging in both just improper conduct all the way to gross violations of professional misconduct. And I'm talking specifically about that case where a plaintiff's attorneys conspired against my client to violate the rules of civil procedure, to send out third-party discovery to another servicer many steps removed, not advising me or my client that they had issued third-party subpoenas, that had sent that discovery out to third party, that had received hundreds of pages worth of documents from third party, never advising me or my client or the court that they had gotten those documents through improper means, and then came into a courtroom, placing those documents down in front of the witness, high-level witness who testified that he was an executive in a major servicer, he was a chief litigation strategist or something like that, an attorney for many years. So again, we're not talking about some low-level robo-perjurer witness. We're talking about a guy who sat at the very pinnacle of this whole finance industry and banking. The attorney put these records that they had detained through improper means in front of this witness, and this witness testified over and over again that they were, quote-unquote, his records, his company's records that had been boarded onto their system, when in fact what is revealed by the evidence itself was that those documents were obtained through false means from a prior servicer. I know that's complex, and I know I got into that very quickly, but the reality is that's an example of gross misconduct that occurred in a courtroom, in a trial, and that after we discovered this, we brought this to the attention to the judge, and the judge likewise just dusted it off and couldn't care less, signed the final judgment, and didn't give us relief. That's another one that's on appeal that I'm frankly desperately hopeful that the second DCA will do something about and will respond to. But the fear is that the appellate court will just say, you know what, we got through this foreclosure thing and all these sins that occurred, all this gross misconduct, we're just going to walk past it and let them get away with it. The harm is not just to the individual litigants in the case. The harm is to the overall integrity of the judicial system, and especially treating and educating these young lawyers that what they're doing is appropriate and they get away with it. It has long-term consequences to the whole of the judicial system, and I hope that one of the end products of this review that we should all be engaging in is to say that this should never occur again.